See, Ms. Champion, are you there?
Yes, Judge, I'm here. You're muted.
Thank you. Would you do us a favor? The printer in the courtroom is not working. Are you able to print out the all-purpose calendar for me with the state's offers?
Yes, I'll print it out and bring it down to you.
Okay.
April, make 2 copies, please.
Okay,
All right, we appreciate it. Thank you.
all right.
Thank you.
Good morning, everyone. Hope everyone's doing well this morning.
Good morning, Your Honor. Good morning, Your Honor.
This is your choice.
Ms. Woodbury. Good
Yes,
morning.
Judge. Good morning.
Are we going to be able to deal with Ms. Fagan today?
I suspect we will, Your Honor. I would just request either a breakout room or a phone call with her when ACDC has a moment, and I suspect we'll be able to resolve it.
Okay, has she found a place to, have you all found her a place to reside?
We have not, Your Honor, but I confirmed from Behavioral Health Court that they're in the process of finding her a place and that the jail won't release her until they found a place.
Okay, all right, so, well, good, thank you. And we'll put you into a breakout room when they come on.
Thank you so much.
Thank you. Good morning, Mr. Walker. Hope you're well.
Good morning, Your Honor. I hope you're well as well.
Thank you. And I guess whenever courtroom 2 is ready, we'll be ready.
Your Honor, we're ready. We have position number 23 and 24. Mr. Trayon Love. And one more position.
And this is going to be a negotiated plea.
What number we on? 23 and 24. Okay. Good morning, Your Honor.
Good morning, Mr. McLean. I hope you're well. Good morning. This is Mr. Love. Good morning, Mr. Love. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Let's see, Ms. Campbell, good morning.
Good morning, Your Honor. Good morning, Your Honor. This is actually my case.
Okay, good morning, Ms. Dillingham.
Good morning. So, Your Honor, the state's offer that was negotiated and agreed upon was 12 months to serve 32 days, credit for time served 16 days, balance suspended with a stay away order from 217 Thirkled Avenue, that's spelled THIRKLED Avenue Southwest, and a no further contact with Kenneth Jones.
Mr. McLean.
Your Honor, my client stipulates all necessary elements and asks the court to accept his negotiated plea of guilty.
Okay. And the position 24 is going to be null pros, is that correct?
Yes, Your Honor.
Okay. Mr. Love, it's my understanding in case 18 CR 010678A, you wish to plead guilty to criminal trespass, is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
Okay, I'll accept the plea as negotiated, Mr. Love. Good luck to you, sir.
25 minutes. Is it? Next, Your Honor, we have position 25, Mr. Craig Nelson, position 25.
And what are we going to do with Mr. Nelson this morning?
That's a negotiated plea also, Your Honor.
Okay. Thank you. Good morning, Mr. Nelson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes,
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. Thank you, sir. Still in him.
Yes, Your Honor, this was a time served offer, 12 months to serve 32 days, credit for time served 16 days, balance suspended with the stay away order from the MARTA at 1255 West Peachtree Street.
Mr. McLean.
No, that's correct. He asked the court to accept his negotiated plea of guilty and he stipulates to all necessary elements.
Mr. Nelson, it's my understanding that in case 23 CR 001098F, you wish to plead guilty to criminal trespass. Is that correct?
Yes,
Are you under the influence of any drugs or alcohol this morning?
no,
You've been represented by counsel. Are you satisfied with his representation?
yes,
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you've given up your right to a trial by jury?
yes,
Has anyone forced or coerced you to plead guilty?
no.
I'll accept the plea as negotiated, Mr. Nelson. Good luck to you, sir.
Thank you. Next, Your Honor, we have position number 18, Mr. William Jude. Position number 18.
Okay, thank you. What are we doing with Mr. Jude this morning?
Morning, Judge.
Good morning, Mr. Jude.
Good morning.
Mr. Finland, good morning. How are you today? Good to see you.
Good, good to see you as well. I hope you've been well.
I have. I hope you have been well as well.
Thank you, Judge. This is gonna be, he's gonna plead not guilty, Judge. I just want to address bond for Mr. Jude.
Okay.
And Your Honor, this might need to be a breakout. This is Naomi Campbell on behalf of the state. The state did have some MH issues that it wanted to bring before the court.
Okay. Let's see. If this is going to, he is going to plead not guilty. It's my understanding. And Mr. Finling, he is deemed competent enough in your mind to be able to plead not guilty. Is that right?
Judge, from my communication with Mr. Jude, I feel confident that he is competent and fully understood all of my questions and answered how I was expecting him to answer. So I do feel he's competent, Judge.
Okay, so if that's the case, I'm gonna go ahead and arraign him first, and then if we need to go into a breakout room to discuss the bond issue, then I'm happy to do that. So let me go ahead and arraign him first. Good morning, Mr. Jude. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes,
Okay, can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
yes,
Okay, you can put your hand down. Thank you. Let's see, Mr. Jude, you've been charged in case 23 CR 001092J with criminal trespass and damage to property. This charge carries a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
I do, Judge.
How do you plead, Mr. Jude? Guilty or not guilty?
not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Let's see, we'll go into a breakout room to discuss the issue of bond. Do we have anybody, who do we have at ACDC? Can you all hear me this morning? Good, good morning, Officer Melton. Let's see, do you have Miss Brittany Fagan there?
No, I have position 11, position 14, which is a private attorney, position 21, 22.
Okay, we have an add-on, position 1 of Brittany Fagan. We had her last Thursday, and she was to be brought back today, and I know that her counsel is here, and so
Okay.
whenever, I don't know if she's already pulled or not, but
No, I will
okay.
have her here. You
Okay.
just give me a few minutes, I'll get her for
Okay.
you.
all right, thank you. So can I go into a breakout room now with Ms. Campbell and I guess courtroom 2?
Judge, do you need me to take the other defendants out of the courtroom during this breakout?
No, that won't be necessary. I just don't want it to be live streamed.
Okay.
Okay, who do we have next?
Your Honor, you can go to 4 North.
Okay, who do we have before North?
Position number 15,
And this is going to be an arraignment.
Yes, that's correct, Judge.
And the bond hearing. And let's see, is this Shannon Gross?
Yes, sir.
Yes, good. Good. Judge Eric Morrow, this is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. You've been charged in case 23 CR 001146A with battery. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
You, Judge.
How do you plead, Mr. Gross? Guilty or not guilty?
Not guilty, sir.
You will record. Your case will be returned to the division judge and you'll get notification of your next hearing date. Let's see, what's the current bond?
I had $3,000 surety.
What I have as well.
Okay, is there a history?
Yes. Well, sorry. We got pretrial answer.
Ms. Chester, are you with me this morning?
Yes, Judge.
Yes, good morning. Has he had, Mr. Finley, do you know if he has had a BHUT?
I don't believe so, Judge.
Okay, so I'm not going to change this bond because I issued the bond back in February. As part of the bond, BHET was requested. And if he has not had that, then I'm happy to put it on for another time to give you the opportunity to get that done. But if that has not already been done, I don't see how I can, in good faith, change my own bond order.
Understood, Judge.
Okay. All right. So good luck to you, sir. We'll see you back if and would you make a note, Mr. Finley, that that's a part of the bond order?
Yes, sir. So, and I just want to make sure, so Mr. Gross, you have not completed an MHET.
What is that? I'm not even sure what that is.
Okay. So, all right.
Is it the mental health evaluation?
Yes.
Yes, I have spoken with mental health.
Okay, it was a behavioral health. And so, Mr. Finley, if you want to put him back on for another time, I'm happy to do that. You make sure that that's complete and request that it's put back on. I'll be happy to take another look at it.
Yeah, if you could, Judge, because I'm not seeing in the system, so I can't really verify that.
No, there's not one submitted, so you need to submit one if you want the judge to sign off on one.
Yes, if we could,
Okay.
I'll make a note of it.
Okay. All right, thank you. Who do we have next?
next we have Ms. Fagan, Your Honor. And after Ms. Fagan, we have position 14, her attorney, Mr. Gilbert Sperling, is on the Zoom.
Ms. Woodbury is going to need to speak with Ms. Fagan. What's the
Okay.
best
She
best
can-
way to accomplish that?
She can call 404-865-8122.
Thank you. I'll call that right now.
Okay,
Can we go to position 14, Your Honor?
okay, very good. And this is Mr. Sperling's case.
Yes, Your Honor.
Yes,
Good morning.
Good morning. Let's see, what are we going to do with Mr. Griffin today?
We're going to plead her not guilty, Your Honor.
Okay, Ms. Griffin, okay. Good morning, Ms. Griffin. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes,
Say-
sir.
Okay.
Yes,
thank
sir.
you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay,
Yes, sir.
you can put your hand down, Ms. Griffin. You've been charged in case 23 CR 001087J with battery family violence. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Spurling?
Yes, Your Honor.
Ms. Griffin, how do you plead? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date.
Judge, excuse me, Mr. Spurling, and I don't know if y'all aware, but she has another case, and apparently that case got set for Thursday SAP. Instead of being combined with this case, so I don't know if you just want to go and arraign her on that case number also, or you just want to come back on Thursday on the SAP calendar.
I'll prefer to arraign her on not guilty on that also, Your Honor. I'm aware of the case. I'm on both cases.
And that case number is 23 CR 001104, J as in John.
Okay, so let me go ahead and do that now. And also, Ms. Griffin, you've been charged in case 23 CR 001104J. Is that also battery family violence?
Yes, Your Honor.
With battery family violence, again, that charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of that accusation, Mr. Spurling?
Yes, Your Honor.
How do you plead, Ms. Griffin, guilty or not guilty?
Not guilty.
Again, we will record your not guilty plea. Your cases, both cases will be returned to the division judge, and you'll get notification of your next hearing date. Okay, good luck to you, Ms. Griffin.
And Ms. Griffin, I'll come see you today, okay?
Mr. Spurling, you're excused from Thursday SAP calendar.
Thank you.
Okay, all right. Thank you, Mr. Spurling. You have a good day.
You too.
Thank you.
Position number 34 on 4 North.
Okay. And this is going to be a plea.
I think you have the wrong number.
I have the wrong number. I just let somebody a message. Oh, did you just let somebody a message? Yeah, but if I was calling the phone number. What number is this, Your Honor?
This is position 34, Mr. Paul Richardson.
Okay, that's a negotiated plea, Your Honor.
Okay, thank you. Good morning, Mr. Richardson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Okay, can you speak up for me?
Sir.
Okay, can you raise your right hand? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, you can put your hand down. Thank you, Mr. Richardson. Ms. Dillingham?
Yes, Your Honor. The state's recommendation in this case is 12 months to serve, 28 days, credit for time served, 14 days, balance probated, with 2 conditions: restitution to the victim, in this case, Ashley Moore. We are still waiting on that amount, Your Honor. So I don't have that amount at this time. The other condition in this case was 40 hours community service, and then we would ask it to be changed to balance suspended upon completion of those terms, as well as a no further contact with Ashley Moore and a stay away order from the address 6128 Oakley Road.
What was damaged?
Tires.
Okay, I can't have him plead to an amount that he doesn't, I mean, it could be $50, it could be $5,000. So if he's pleading today, I'm not going to include restitution. If you all don't have a restitution amount, she'd have to go through a civil suit to get any restitution in that case. Okay, Mr. McLean.
Your Honor, my client asked the court to accept his negotiated plea of guilty, and he stipulates all necessary elements.
Okay. Mr. Richardson, it's my understanding that In case 21 CR 006157C, you wish to plead guilty to criminal trespass and damage to property. Is that correct? You're gonna have to be verbal with me, Mr. Richard.
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
Yes, sir.
I'll accept the plea as negotiated, Mr. Richardson. It's you've got 40 hours of community service. Once you complete the community service, the probation will be terminated. So the sooner you get it done, the sooner you won't be on probation any longer, okay?
Okay, thank you.
All right, good luck to you, Mr. Richardson.
You too.
Who do we have next?
Next, y'all, they're gonna come to courtroom 2. This is gonna be position 37, Mr. Rayfield Simpson.
And this is going to be a plea?
Yes, Your Honor, it's a negotiated plea.
Thank you. Good morning, Mr. Simpson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Yeah, you can put your hand down. Thank you, Mr. Simpson. Yes, Ms. Dillingham.
Yes, Your Honor. The state's offer in this case is 12 months to serve 46 days, credit for time served 23 days, balance probated, balance to be suspended upon completion of these courses, 12 weeks of anger management, and an anti-theft course, in addition to a stay away order from the Texaco at 635 Lindbergh Drive Northeast.
And Mr. McLean.
That is exactly what we expected to hear, Your Honor. He asked the court to accept his negotiated plea of guilty.
Mr. Simpson, it's my understanding that in case 23 CR 000990G, you wish to plead guilty to theft by shoplifting, battery, possession and use of drug-related objects, and simple battery against a police officer. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yeah.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yeah.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Simpson. When you complete the 12 weeks of anger management and the anti-theft course, that's the probation is going to terminate. So the sooner you get that done, the sooner you're not going to be on probation, okay?
All right, thank you.
You're welcome.
Thank you, Your Honor. Can I have him
again? Yes. Ms. Woodbury, do you have an announcement?
We're ready to move forward with the plea on Ms. Fagan, Your Honor.
Okay. And it's my understanding that we've already had a discussion about this. It's going to be a non-negotiated plea, but I
I
have
think it's
already.
gonna be negotiated at this point. Your Honor.
It's going to be, okay, very good, Mr. Walker. Thank you. Ms. Fagan, good morning. Judge Eric Morrow, this is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you, ma'am. You can put your hand down. Mr. Walker?
Yes, Your Honor, the state's recommendation is going to be a time serve offer of 142 days, credit for time served of 142 days, balance suspended with no further contact with the victim, Sybil Allen, and a stay away from 2572 Macon Drive in Atlanta, Georgia, as long as Ms. Allen resides at that address.
Okay. Ms. Woodbury?
Yes, Your Honor, that's our agreement, and we specifically agreed to the language on the stay away being as long as Ms. Allen resides there.
Okay. Ms. Fagan, it's my understanding that in case 22 CR 0037633E, you wish to plead guilty to battery family violence. Is that correct?
Correct.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Ms. Fagan. Good luck to you, ma'am.
Thank you, Judge, and thank you, Mr. Walker, for your patience with this case.
Of course, thank you.
Yes, I'm glad we could get it resolved.
And that concludes my business. May I be excused?
Yes, have a good day. Thank
You too. Thank you.
Positions 9 and 10 for North.
Okay. And these are both negotiated, please.
That's correct, Judge.
Okay. Yes. Good morning, Mr. DeSola. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Put your hand down. Ms. Campbell?
Yes, Your Honor. The state's recommendation for position 9 is 12 months to serve 15 days. Credit for the time he's already served, 15 days, and the balance is to be suspended. There's no conditions. And as to position 10, pursuant to the defendant ending a guilty plea on position 9, the state's going to be entering a no pros, nothing further.
Okay, Mr. Finley?
Yes, Judge, that was our understanding of the plea, of which we do agree, and I do stipulate the factual basis. I deem them.
Okay. Mr. DeSola, it's my understanding that in case 20 CR 0000148J, you wish to plead guilty to theft by shoplifting. Is that correct? You're on mute for North.
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. Good luck to you, sir.
All right.
Next, we have position 11, Jordan Doon.
And this is going to be an arraignment and a bond hearing.
That's correct, Judge.
Good morning, Ms. Dune. I'm Judge Eric Moore. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Is that a yes?
Yes.
Okay, you're gonna have to speak up for me, ma'am.
Yes.
Okay, thank you. Can you raise your right hand? Do you swear and affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Ms. Dune, you've been charged in case 21 CR 007760D with driving under the influence of alcohol, less safe, and striking an unattended vehicle. These charges carry a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
I do.
How do you plead, Ms. Dune? Guilty or not guilty?
Not guilty.
We will record the not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date.
This is a bond forfeiture case judged by Judge Edline. She bond forfeiture on
Okay.
February the 18th.
It's my understanding, Mr. Finley, that this is a bond forfeiture case from Judge Edline's court. You know that it's my practice that if another division judge has issued a bond, that I return it to them so that they can modify that bond if they choose to. So if you'd like to have that bond modified, you can go back to Judge Edline, okay?
Understood, Judge. Is it possible to have her put on an upcoming calendar so she can reconsider a plea?
Which calendar would you like to have her put on, Mr. Finley?
Possibly. I'd say in a week or so. I know she wanted to kind of see what happened with the bond and then
Okay,
So you want to reset for the 21st or the 28th?
so the 21st is next week. You want to reset for next week?
We could, yeah. the 21st.
Okay, we will reset her for the state all-purpose calendar for next Tuesday.
Understood. Thank you.
Okay, all right. Who do we have next?
We can go with position 21, 22, Miss London.
And this is gonna be a plea,
This is gonna be a plea as well, Judge.
okay? Good morning, Ms. London. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Ms. London. Ms. Campbell?
Is this a negotiated plea?
This is a negotiated plea.
Okay, the state's recommendation for position 22 is going to be 12 months to serve 180 days. Credit for the time already served 90 days. The balance is to be probated. And there's to be $2,000 in restitution paid to the victim in this matter, which is an apartment complex, and I'll give that name in a second. The probation can be terminated upon payment of the restitution. And I'm asking that those sentences run concurrently on both the counts in position 22. And pursuant to a plea being entered in 22, the state is going to null pros position 21, which is an FTA.
Okay, Mr. Finley?
Yes, Judge. That is our understanding of the offer, of which I did go over with Ms. London. She understands that after the restitution, her probation will be terminated, so we do agree to that. And I do stipulate the factual basis venue and ID check.
Okay, Ms. London, it's my understanding that in case 22 CR 005740H, you wish to plead guilty to criminal trespass and terroristic threats. Is that correct? Say it louder for me.
Yes, sir.
Thank you. Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
No, sir.
Um,
Say that to me again.
You don't want a jury trial, do you, Ms. London?
No, sir.
Okay. Has anybody forced or coerced you to plead guilty?
No, sir.
I will accept your plea as negotiated, Ms. London. As soon as you get the restitution paid, the probation will terminate. So the sooner you get that done, you won't be on probation anymore, okay?
Yes, sir.
All right, good luck to you, Ms. London.
So when I pay, do I get out or can I get out?
It was a time served, please. So if you don't have anything that's holding you, then you will be released as soon as the jail can process you out.
Okay.
Okay.
Thank you.
And I'm sorry, Your Honor, just the name for the restitution is the Darren Village Apartments. And there's also a specific name of Miss Charlene Hunter.
Can you please send that to me in an email to Katrina Lewis so I can write it down on the paperwork for probation?
Sure.
If you can email it to me, don't send it in the chat because I'm not able to look at the chat at the same time.
Okay, I'll send you an email. Thank you.
Thank you.
Thank you, Ms. Campbell. Okay, who do we have next?
Position 26, Mr. Parham.
Okay. What are we doing with Mr. Parham this morning?
Good morning, Your Honor. Mr. Parham tells me that he already took that class, and we're trying to figure out if we can prove that this case has already been settled. His recollection is very specific. We've been trying to get hold of his mother since yesterday to see if they can look at his emails, get the certificate of completion, and find out whether there was an agreement. He says he had an attorney at the time, that he emailed the attorney or the prosecutor or both. There's been a little time on this, so I was surprised that his memory was good enough for that year.
Okay, so if he goes on, probation, then he'll be able to prove to them that he's already taken the anti-theft course, and he also had the restitution of $119.26, right, Mr. McLean?
Right. Now, he did not say that he was instructed at the time to pay restitution then, so he was pretty clear on that.
Okay, so all I'm saying is that he can clear all this up with probation.
Okay, cool.
Is that right, Mr. McLean?
He could do that, Your Honor. Now, he has a case tomorrow with private practice attorney in another matter, and that's tomorrow the 15th. And we anticipate being able to be free from the jail at that time. So he was anxious to clear this up today. I did advise him that there are 2 ways to go, and not guilty asking for a signature bond, or saying, well, I can't remember that it was a diversion case that I actually earned, so I won't insist on that. Mr. Parham, what's your decision today? You want to ask for a not guilty and a signature bond? Because naturally cases go to trial on a not guilty.
No, I already plead guilty.
Okay, I understand. It sounded like he was describing a diversion situation, Your Honor. So he's saying if it's how do you pronounce it? Ultra-flow acquit, not acquit, but convict. That's one situation, but the Odyssey is not showing the case settled.
Whatever I need to do, like, that won't hold me back in jail, like, for tomorrow when I bond out.
The clerk's record is not showing that there's already been a plea entered and accepted and sentenced upon. So if you want to do that today, fine. If you want us to continue to research it, I would plead you not guilty and ask for a signature bond considering the circumstance.
Okay, so like with the signature bond, would I be able to be released?
Not tonight, because you have tomorrow's hearing on which you believe you'll be released.
I'm not talking about tonight. I'm saying like once I bond out on my other charges.
If nothing else pops up, that is true.
Okay, that's cool.
So what do you want to do?
That's what I want to do. Take the signature bond.
First off, Mr. Parham, I don't know anything about your case, and I'm going to be the one to decide whether you get a signature bond or not. I haven't heard anything about your case. I don't know anything about your case today, tomorrow, your history, or anything. All I know is that you probably have a bond for this theft of services. I'm not even sure what that bond is at this point in time. So if you want me to take a look at it, get your history, and to make a determination as to whether I'm going to convert the signature bond into the good bond into a signature bond, I'm happy to do that.
But she already had a
Okay.
bond.
Yeah, I already. Yeah.
Hold on 1 second for me.
He already has a sign of the $3,000 SOB through the jail on this case.
Did you hear that, Mr. McLean? He already has a signature.
I did. If this case is not holding him in, then he is good to go if he succeeds in his hearing tomorrow. That's fine.
Okay, is that your understanding, Ms. Dillingham?
Yes.
I am showing the $3,000 signature bond, Your Honor.
Okay, so this case is not holding you in, Mr. Parham.
Very good.
Okay, does he need to be, has he already been arraigned on this?
No.
Okay, I need to arraign him, Mr. McLean.
That's fine.
All right, so Mr. Parham, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Put your hand down. Thank you. Mr. Parham, you've been charged in case 22 CR 002937H with theft of services. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive from the reading of the accusation, Mr. McLean?
We do, Your Honor.
How do you plead, Mr. Parham? Guilty or not guilty?
Guilty.
I thought we had a discussion just now, Mr. Parham, that you were going to plead not guilty today.
I don't really know, because I had went to court already for this and plead guilty, and they gave me an arrangement to do the classes and all that already. So whatever it takes for me to go and get out of Like,
As we discussed, Mr. Parham, this case is not holding you in. You have a signature bond on this theft of services. It was my understanding that you were going to plead not guilty. And once you plead not guilty, and if you do get out on that other case, then you'll be able to research this case so that you can determine what you would like to do with the charges. But to do that, you would have to plead not guilty today.
so to get out, you saying I had to plead not guilty?
No, I'm not saying, Mr. McLean, I'm gonna have to let you talk to him.
I
So,
need to talk to him some more, Your Honor.
all right.
I'm
So-
gonna plead guilty. I'm telling you, I'm gonna plead guilty.
Mr. Parham, regardless of how you plead today, you already have a signature bond. This case is not holding you in. If you're telling the court that you think you've already dealt with these charges, then you'd be able to get out at some other and come back at some other point to deal with the charges. You understand that? This is not holding you in jail. Then.
Yeah, I understand that's not holding me, but I'm telling you, like, I already plead guilty and they gave me the arrangements. So if I
Okay,
plead
well,
not guilty.
we don't have that. We don't have that in our records. And if that is the case, then once you got out, your attorney would be able to research that for you.
Okay, cool.
Okay.
Right, he has
so-
paid private lawyers in both cases, so I think that is the best way to go.
Okay, so how are you pleading to this theft of services today? Guilty or not guilty?
Guilty.
Okay. So, Mr. McLean, unfortunately, I'm gonna have to put him off and let you talk to him some more. So I don't know if you can do that today. If you can't do it today, we're gonna have to reset this until next Tuesday, and he's gonna be.
Oh, no.
Your Honor,
No, I ain't trying to.
Sir, please be quiet for a moment. Thank you. We have a phone over here, and if from 4 North, they can have him call me on this phone. I think we will be able to resolve this today.
Okay, very good.
It was just a misunderstanding.
We're going to clear up that misunderstanding. Don't worry.
Hello. Your Honor, can we put that to the back for a minute? I have the next 2 clients I have in here. In courtroom 2 are for McLean.
Okay.
2 negotiated pleas, Your Honor, number 46 and number 40.
Okay.
And this is number 46, Mr. Damian Young.
Good morning, Mr. Young. I'm Judge Eric Morrow. This is a state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. Ms. Dillingham?
Yes, Your Honor. The state's recommendation in this case is 12 months to serve 28 days, credit for time served 14 days, balance probated until completion of the course of the FVIP course, and then no further contact with Alexis Crenshaw. After the FVIP course is completed, it can be changed to balance suspended.
Okay. So you're allowing the probation to terminate once he completes the course, is that correct?
Yes, Your Honor.
Okay. Mr. McLean?
Your Honor, the only complication is that he will be going out of state on a hold as soon as we do this plea. I'm sorry. We do have a Columbia County in Georgia. You're absolutely right. He'll be going somewhere, Your Honor. So as soon as he's through with that legal matter, then he'll be coming over to 132 Mitchell Street, the JCS probation people, to begin the FVIP and be on probation. I would ask the court to consider giving him a financial break because that course is somewhat expensive. Your Honor, he stipulates the 3 necessary elements and asks the court to accept his negotiated plea of guilty.
Okay. Mr. Young, it's my understanding that in case 22 CR 001326A, you wish to plead guilty to simple battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol today?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Young. Let's see, I think that 3 months should give you enough time once you get out to find yourself a job. So I will waive 3 months of probation fees to help you get and stay on your feet. And when you complete the family violence intervention course, the probation will terminate. So the sooner you get that done, the sooner you won't be on probation anymore, okay?
Yes, sir. Thank you.
Good luck to you, Mr. Young.
Thanks, sir.
Yes.
Position number 7.
I thought we were going to do 40, Your Honor.
If we do 40, that clears one person from this room.
Okay, let's do position 40 first then. That's Lance Williams, and that's going to be a negotiated plea also, is that right?
Yes.
All right. Good morning, Mr. Williams. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. Ms. Dillingham?
Yes, Your Honor, this is a time served offer, 12 months to serve, 36 days, credit for time served, 18 days, balance suspended.
Mr. McLean?
Your Honor, after discussing the facts of the case with him, he asked the court to accept his negotiated plea of guilty. It's time served, balance suspended, and he stipulates to all the necessary elements.
Okay, Mr. Williams, it's my understanding that in case 18 CR 009346E, you wish to plead guilty to driving without a valid license, rear view obstruction, and defective or no tail lights. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, I'm not.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Extremely.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, I do.
Has anyone forced or coerced you to plead guilty?
No, they have.
I'll accept your plea as negotiated, Mr. Williams. Good luck to you, sir.
All right, thank you.
Thank you.
Appreciate it. Thanks, man.
Good to meet you.
Yes, same here. Hope I don't meet you on the street next time.
All right. Where to next?
Position 7, Mr. Cotton.
Okay. And this is going to be a non-negotiated plea?
It is, Judge. Mr. Cotton,
Yes.
we can speak privately if we need to, but do you still want to go forward with the plea? I didn't have a chance to.
I'm trying not guilty.
Okay. So I'm gonna need to speak with him briefly, Judge. I don't know if we can move on to somebody else.
Okay. Let's see. Are you gonna call for North, Mr. Finley? No?
Yeah, if I can. What is the number over there?
Hold on, I'll call you. Just give me a moment.
Okay, thank you.
Okay. Do you want to go to 5 North?
Yes, we can go to position 38.
Okay. And what are we going to do with Mr. Walton this morning?
Number 38, let me grab that, Your Honor. Let's see, Tracy Walton. I believe he may have been, if I can check, Your Honor. Sorry. Thank you for your indulgence. And again, what number was that? Let's see.
38.
38. If I could get back with the court in just a minute on that and make the announcement, Your Honor, I don't believe. This is one of those cases where we did not interview him yesterday because of the circumstances.
Okay, so you need to speak with him this morning?
I
Mr.
do.
McLean? All right.
That's correct.
Okay, so I guess you all, so Mr. Finley needs to speak with 4 North. You need to speak with 5 North.
Right.
So
Now, if 5 North could call the extension to 2391, I can answer that phone.
Are you able to do that, 5 North?
That's one digit different from the other phone. This is 2391, but it's a 612 number.
I'm calling it now. Answer the phone.
Okay, thank you. So I don't think that there's anyone else that we can take right now. So until either Mr. Finley or Mr. McLean comes back, court will be in recess.
Judge, I'm actually,
Yes.
I'm actually ready on Mr. Cotton.
Okay, and that was position 7?
That was our position 7.
Okay, what are we gonna do with Mr. Cotton?
Mr. Cotton wanted to plead not guilty and wanted to address bond on his behalf.
Okay. Yes, Mr. Cotton, this is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you. Mr. Cotton, you've been charged in case 20 CR 004026Y with battery, family violence, criminal trespass, damage to property, and cruelty to children in the 3rd degree. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive for the reading of the accusation, Mr. Finley?
I do, Judge.
How do you plead, Mr. Cotton? Guilty or not guilty?
Not guilty.
You will record your not guilty plea. Your case will be returned to the division judge and you will get notification of your next
Also,
hearing date.
forfeiture case with judge.
Okay, I'm being told that this is also a bond forfeiture case with Judge Edie. So, Mr. Cotton, if you would like to have your bond modified, you'll have to go back to Judge Edie's court. Good luck to you, sir.
All right. And yes, so Mr. Cotton, so we're not going to be able to get your bond lowered or modified today. You want me to ask for you to be put on possibly court for next week so you can reconsider?
Well, if that's the case, can I change what I just said then? Okay.
Okay. Do you want to move forward with what we talked about yesterday with the plea? It's up to you.
Yep. Yep.
Okay. Are you sure you want to move forward? Or do you want to, move it a week and we can talk about it more, whatever you want to do?
Let's go and move forward.
Okay. All right, Judge. I already went over the questions and all that with him yesterday, so.
Okay.
Please paperwork.
Ms. Campbell, is this your case?
Yes, Your Honor. The state's, I'm sorry, are you ready for the state's recommendation?
Yes, go ahead. Go ahead.
Okay. It looks like the state's recommendation for Mr. Cotton is going to be, hold on, 12 months to serve, 36 days. Credit for the time he's already served, 18 days. Balance is to be probated. He's to complete a family violence intervention program, have no further contact with the victim, and stay away from the incident location. The victim's name is Alexis Dorsey, and the incident location is 32000 Lakeview Place, apartment 173 in East Point. And if this is a non-negotiated, the state's prepared to go into why this is its recommendation.
I think it's negotiated, right, Mr. Finley?
Judge, this is non-negotiated with,
Okay.
with the no further contact and stay away edition.
Okay, let's see. Has someone spoken to Ms. Dorsey?
I have, Judge. I spoke with Ms. Dorsey for a while last night.
Okay, and
she was, yes, Judge. So she was unable, she wanted to be on the Zoom, but she was unable to. But she is working right now. But she does want to have contact. She does want it to be no further violent contact and does not want there to be a stay away, Judge. They do live together. They have one kid together already, and they have one child that's actually on the way. So she's pregnant right now and she's due in June.
okay. Ms. Campbell.
Your Honor, the state is requesting a no further contact and a stay away. This defendant actually currently has a $3,500 cash bond in this case. And that's because he FTA'd back in 2022 on this case. And his bond was actually forfeited as a result. I'd also like to add that he has 6 cycles, to include a 2022 battery that's currently open in Walton County, for which he has FTA'd twice on that case as well. He also has a no bond hold currently out of Clayton County. So part of the reason for the state's recommendation is just the criminal history alone, which is that he has multiple batteries that are open. I guess one's getting ready to be closed today, but he was FTAing for the cases and not taking accountability for them. So the state is concerned that if there's a no violent contact and a stay away is not put in place, the state is concerned that there's no guarantee that he's not going to reoffend. Because to me, based on his inability to show up for court, he's just not a trustworthy individual. So I don't know that if he's given a no further violent contact, that he might not go home and batter the mother of his child again and then not show up for court again. So the state believes that the no further contact is necessary. The facts are that the defendant actually forcefully tried to take the victim's car keys away from her. And this was all the way back in 2020 at their apartment. And when the officer arrived, he saw injuries on the victim's arms, sides, and shoulders. And he observed damage to 3 doors in the residence and on the wall in the residence that was done by the defendant during this incident. And most concerning to the state is the fact that their 2-year-old child was present when this incident took place. And their 2-year-old child observed this. That's why he's also been charged with cruelty to children. So the state believes that in light of the fact that this is his second battery between 2020 and 2022, that a no further contact is appropriate. And the victim's not here to say that she's not requesting no further contact. We're just being told that from the defense attorney, but she's not present. And the state is just concerned for her safety. And the state is also concerned for the child's safety in light of his history and in light of these facts. So that's the state's recommendation.
And
Well, Mr. Finley is an officer of the court. I don't think that that he would make a representation to this court without having spoken with her. So my concern is that, Ms. Campbell, do you have it's a $3,500 cash bond, do you know what the conditions on that bond were?
I can look. It was just, the only reason why it was issued is because the FTA and the bond forfeiture. So I was looking at the order. If you'll give me a second to go back in the order.
Hey, can y'all hear me?
Yes, who's speaking?
This is Miss Oliver. I was told that DeMarcus Yarbert was having court today, but I didn't see him.
Well, we're still in the middle of court at this point, ma'am. So I'm not sure if what's his name?
DeMarcus Yarbert, last name Yarbert.
We haven't got to him yet.
Yeah, we have not reached him yet, ma'am.
Okay, so but y'all still so is court still going, right?
Obviously.
Okay.
Let's see. Your client has his hand up, Mr. Finley.
yes, sir. And please don't speak to the facts of the case, okay?
Your Honor,
Say what?
I said, just please don't speak to the facts about the facts of the case. I just don't want you to say anything that's going to hurt you, okay?
Oh, well, she hasn't made it to work yet. If you want to call her, you can call her.
I don't, yeah, I can call. I don't have my cell phone, but is that phone being used right there?
Yeah. Mr. Finley, you're fine. I will take your representation that you've spoken with her and what her desire is.
No, I have that.
What I'm concerned about is if there was a condition on that first bond that there be no further contact, then that's going to make a decision. That's going to play in my decision as far as what I'm going to do this morning. So I need someone to.
I'm
find
looking
out.
now, Your Honor. I
I
apologize.
understand. No, you're fine, Ms. Campbell. I just wanted you to know my line of thinking.
You're speaking of the other case, Judge? The other,
No, I'm talking about in this case. If there was a no further contact in this case, and he's telling me that he has a child on the way with Ms. Dorsey, then there is an obvious violation if there is a no further contact.
right, understood.
So
Understood.
It just says the bond amount and that it's a cash bond only. For whatever reason, I'm not seeing an order in Odyssey to include the conditions, maybe because of the age of the case, but
okay.
You're not gonna see the order in the Odyssey. It's gonna be from the original bond. Like he got a surety on one of the charges and the other one was a signature bond. There's a way of getting to it, but however, my Odyssey is acting up, but I can't get to it at this point.
Okay. And Ms. Campbell, none of these other cases that he has, this is the only case that where Ms. Dorsey was involved. Is that correct?
I can give you a definitive answer because it was in Walton County and I wasn't able to access who the victim was in Walton County. But it was from 2022 and it was a battery.
Okay. Mr. Finley, anything further?
Nothing further, Judge. Just that, like I said, they do have one child together and one on the way. That is due in June. And obviously, I've said before in court that I wasn't going to ask for a no further violent contact because the victim told me they didn't want contact, which I completely abide by. So once again, Judge, this is just what she told me. I'm just relaying that she said she does want to have contact with him and does want them to live together.
Okay. Given the date of this case back in 2020, that I've not been presented with anything that's occurred between 2020 and today's date with Ms. Dorsey, given Ms. Dorsey's desire to have Mr. Cotton in her life, and given the fact that they have children together, I am going to, my ruling would be a no further violent contact, but he would be on probation for the entire 12 months so that we could monitor him during that 12-month period. So if that's what he wants to accept, Mr. Finley, that would be the order of the court.
Understood, Judge. Do you understand, Mr. Cotton, and do you want to move forward, sir?
Yes, I understand. Said probation.
Yes, sir. So you just have to do, it's a family violence intervention course, and then just a no further violent contact. So obviously, you just gotta, walk a fine line and. You want to move forward, sir?
Sure.
Okay. Anything further before I take the plea?
Nothing further, Judge. It just so you can get on back on his feet, if probation fees to be waived for a period of time.
All right, Mr. Cotton, it's my understanding that in case 20 CR 004026Y, you wish to plead guilty to battery, family violence, criminal trespass and damage to property, and cruelty to children in the 3rd degree. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yeah.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea. Your plea, Mr. Cotton. The sentence is going to be 12 months to serve 36 days, credit for time served, 18 days, balance probated, a family violence intervention course, no further violent contact with Alexis Dorsey. I will waive 3 months of the probation fees to give you the opportunity to get a job. And good luck to you, sir.
Can we do position number 8, Davis?
What's the announcement on Mr. Davis?
Yes, Judge, this is gonna be a plea. The only issue that I did have is that, there's no dollar amount listed under the restitution. So he did want to move forward with the plea, but obviously couldn't agree to the restitution amount, of which we don't know.
Have you been able to find out what the restitution is, Ms. Campbell?
No, Your Honor, we haven't made contact to confirm that amount.
Your Honor, we heard from the victim and the insurance covered everything. There's no restitution.
Okay, thank you, Ms. Walker. All right, so there's no restitution, so this is a negotiated plea.
All right, Mr. Davis, do you hear that? So there's no restitution, so we'll move forward with the plea, correct?
Yes, sir.
Okay. Good morning, Mr. Davis. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me?
Yes, sir.
You swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down. Thank you, Mr. Davis. Ms. Campbell?
Yes, Your Honor, the state's recommendation is 12 months to serve 30 days, credit for the time he served, 15 days, and the balance is to be suspended. Nothing further.
Mr. Finley?
That's our understanding of the plea offer, Judge, of which we do agree.
Mr. Davis, it's my understanding that in case 23 CR 001177F, you wish to plead guilty to strike. Are you listening to me, Mr. Davis?
Yes, sir.
You wish to plead guilty to striking an unattended vehicle, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning? Is that a no?
No, sir.
You've been represented by counsel. Are you happy with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and if by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Good luck to you, Mr. Davis.
Thank you.
Position 38,
Okay.
Mr. Walton.
And
Come on. 38.
Uh, 38, Your Honor, Tracy Walton.
yes,
A brief conversation was extremely clear in revealing that we need to reset this case for a social worker visit and get confidential records and have them interviewed by professionals that are not attorneys.
okay. When would you like to have the case reset until?
This,
Mr. McLean?
this particular case is going to need 2 weeks, Your Honor.
Okay. A 2-week reset.
Thank you.
Okay, we'll see you back in 2 weeks, Mr. Walton. Where to now?
Can we do a breakout session with 4 North and Mr. McLean in courtroom 2?
Is that going to be Mr. Parham and me explaining to him?
Yes, it is.
That's fine. I got his mom on the phone finally. Thank you.
Okay, so you want a breakout, Mr. McLean, with 4 North and courtroom 2?
That's fine, Your Honor.
Okay, so if we can put 4 North and courtroom 2 into a breakout room, and then I guess court will be in recess until they return.
Hello? Can anybody hear me?
Yes, who's speaking?
This is Officer Duffy.
Officer
Uh,
Duffy, go ahead.
Position 17,
Okay.
Mr. Johnson.
Everyone's in a breakout room right now, Officer Duffy, so I'll take you as soon as, and they're in with the, with courtroom 2, so they'll have to come out of that breakout room before I can, move forward, okay?
All right, thank you, sir.
You're welcome. I'll let you know when we're ready.
All right.
Say, Johnny.
Yes, who's speaking?
This meeting is being recorded.
Go in the broadcast, go in the room and then broadcast and talk to them and tell them to come out and meet.
No, get back. Mr. McLean? You are mute, Mr. McLean, if you're speaking to me.
Okey doke, Your Honor, I have some announcements.
Okay.
Position 26 is seated before you.
I'm sorry, I didn't hear that.
Position number 26.
Apparently they have position 26. I need your announcement first, Mr. McLean.
Okay. Your Honor, Edward Rhodes has, I believe, 4 outstanding shoplifting cases, if I'm correct, from looking overall at his Odyssey situation. I see 4 different dates, 4 incidents, and 2 of those incidents are on today's calendar. If the 2 that are not on today's calendar have already been taken care of, then I'm going to.
Position number 26. This is not Rhodes.
No,
No, he's given the court announcement. We'll be with Mr.
okay.
We'll be with him in just a moment.
Okay.
I'm going to ask for a 1-week reset to see if we can get all 4 cases together. If I'm mistaken and the 2 cases that are not on the calendar are already resolved, I heartily apologize to Mr. Rhodes. But I think the situation is that it would be better to have a global
Okay, you're right. So positions 30, 31, 32, and 33, Mr. Rhodes will be reset for 1 week until 3/21.
Right.
Okay.
To notify the solicitor in advance of what we're looking for. It's 2 Circle Ks, 1 BP, and I don't know.
Okay, any other announcements, Mr. McLean?
Your Honor, Mr. Yarber is going to be a not guilty and Raymond.
Okay, so we'll get to Mr. Yarber when he comes up, I guess. So can we go back to Mr. Parham, position 26? What's Mr. Parham gonna do?
Mr. Parham is an arraignment today. He's a not guilty. He can take care of that matter because, as we know, it's not holding him in jail. Jonathan Melnick is his lawyer on that old matter, and if Mr. Melnick wants to come back into the case, great. Otherwise, we'll see Mr. Parham on another day.
Okay, so with Mr. Parham, I'd gotten to the part where I asked Mr. Parham, how do you plead to these charges after we went through the total arraignment? How do you plead to 22 CR 002937H theft of services, Mr. Parham? Guilty or not guilty?
Not guilty.
Okay, we'll record your not guilty plea. Your case will be returned to the division judge and you will get notification of your next hearing date. Good luck to you, sir.
Okay.
Next is number 16, Jackson.
Okay.
Also, Your Honor, there's an announcement on Stephen Keys.
Okay, hold on. I'll take those announcements in time. Let's go ahead and do Mr. Jackson, position 16.
Thank you.
What are we doing with Mr. Jackson this morning?
Yes, Judge, this is going to be plea.
Okay. Good morning, Mr. Jackson. I'm Judge Eric Moore. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yeah.
Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down, Mr. Jackson. Yes, Ms. Campbell.
The offer for Mr. Jackson, it looks like it is 12 months to serve 30 days. Let me double check. 12 months to serve 30 days, credit for the time he's already served, 15 days. The balance is to be probated. There's to be no further contact with Yvonne Bass, and that's spelled EYVONNE. And he's to stay away from 2401 Joseph E. Boone Boulevard. He's also to complete the Family Violence Intervention Program, nothing further.
Mr. Finley.
Judge, I did go over the plea offer with Mr. Jackson, of which he does agree. And we would just ask that they do have a child together, so that would be like a third party transfer. But and then just once he completes the family violence class, he could go non-reporting, Judge.
Okay. Mr. Jackson, it's my understanding that in case 23 CR 001088Y, you wish to plead guilty to simple battery, family violence, and criminal trespass. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
Is that a no?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Jackson. Let's see, there'll be third-party transfer of any minors for visitation. And once you complete the Family Violence Intervention Program, the probation will go to a non-reporting status, okay?
Okay.
All right, good luck to you, sir.
Thank you.
Next is position number 19 and 20, Mr. Keys.
What are we doing with Mr. Keys today?
Your Honor, this is a situation where it involves medications, and I believe hopefully one or both of the parents are on Zoom with us today. I have not looked at the gallery to see if the parents are on Zoom.
So what, did you have the names so I can sound for them?
I believe they are. I believe the Golden Gate Bridge is a background. I'm pretty sure that would probably be them.
Okay.
And they're
I
like,
see them here, and I think that we've been reset before and that they've been here before. So,
Mr. Keys and I had a conversation in which he has agreed to take the shots. We believe the shots are far more effective than the pills, and he's agreed to take the shot.
okay, so what does that, in terms of what we're doing with Mr. Keys today, how does that play into what we're doing?
What I'd like to do is at this time, Your Honor, plead him not guilty and have him arraigned and ask for a signature bond on condition that he follow his doctor's orders on the medication.
And is he going to reside with Mr. and Ms. Keys? How?
There was a situation, Your Honor, where for a while he was residentially challenged, and that seemed to be a problem, and they felt like taking him back in. But I said, you know, I'm not sure that really comports with a previous court order. However, that's a court order in a previous case that it's a little bit confusing as to the dates. Now, unfortunately, it's very sad that the case that involves Brian, his brother, as a victim, Brian had high blood pressure and passed away last year. So I need to talk to the state about that case and its future. But the case involving him being accused of iced coffee to daddy's neck or back of the head, something like that, that's the case that I'm principally looking at asking the court for a signature bond with condition that he take those shots and he'll be right as rain.
Okay, well, Mr. McLean, I think that, I know the parents are here. You have not spoken with the parents?
Oh, no, Your Honor. I spoke to the parents for an hour and a half over the weekend.
Okay, and what is their desire? I can
desire is to have him home.
Okay, and is this, are their last name Keys? Is this Mr. and Mrs. Keys here?
They need to unmute.
Yeah.
Okay, and if you all can raise your right hands for me? Do you swear from the testimony you'd like to give before this, that you're about to give before this court, be the truth, the whole truth, and nothing but the truth?
We do.
Okay. So, Mr. and Ms. Keys, what is your desire in regards to your son today?
The issue is that we have no problem with him coming home as long as he has somewhere and he's going to take his medication. That's our only concern.
We're breaking up a little bit. Would you repeat that about as long as what?
He's taking he's on his medication, and his doctors can say that he is taking his medication.
And do you agree with the shot? I mean, you told me about the shot is much better than the pills, and Mr. Keys Jr. agreed.
Yeah, that has effective.
That's been the main thing, is the shot works so much better than the pills in his situation. It's a monthly shot.
And let's see. Okay, you've got a lot going on. Okay, hold on, just give me a second, Mr. Walker. We have a lot going on here, and I'm trying to, and I'm sorry if this is the case. Mr. Ms. Keys, did your son Brian Keys, did he pass recently?
A year ago.
Oh, he passed a year ago. I'm sorry for your loss. So he was. It's my understanding, Mr. Walker, if that's the case, he's the victim in one of these cases, right?
That might be the case.
He's the victim. Yes, he is the victim in one of the cases. He FTA'd for that case. The defendant FTA'd for the case where the brother is the victim, Brian Keys.
So,
Oh,
He asked,
Mr. Campbell or Mr. Walker, if that's the case and the parents are saying that their son passed away and he was the alleged victim in that case, would you all be requiring a death certificate?
Yes, we will. And once we get a death certificate, we will close out that case and we can get the death certificate on our own. I don't know if you remember, but I believe Mr. Keys was on our competency counter on Thursday and Mr. Howard was representing Mr. Keys. We all agree that it was not in the best interest of Mr. Keys to return to his parents' home. Him and his father have a history. This is not the first violent instance that they've had between the two of them. And Mr. Howard's last announcement to the court on Thursday was that he was finding Mr. Keys alternative housing. So I don't know if Mr. McClain.
Okay, thank you.
I
I
would
didn't
certainly
remember
defer to that. I trust Mr. Walker. We've known each other for a long time. I will trust that representation and defer to that judge.
We have no problem with that.
Okay, so what we're gonna do is we're gonna let this continue on the competency calendar.
Very good.
Okay, all right. Did we place him on, I'm sure we did, Mr. Walker. We placed him on another competency calendar sometime.
I'm trying to check now. I'm sorry.
No, you're fine.
Main point being that at least we made a little progress today in getting the agreement on the shot. That's a good thing. Thank you.
I don't see him being reset as of now. I will have to check with Mr. Howard, but if we could put him on this Thursday's competency calendar, and I will get with Mr. Howard.
Okay, so that's the 16th.
Okay.
Okay, and if you wouldn't mind also getting in touch, and I know that they've been here before, and I'm not sure if they've been with us at the competency calendar, but if we could also get in touch with Mr. and Ms. Keys, and so they can be present at that calendar if they choose to be.
Thank you.
Thank you, Judge.
You're welcome. Okay, so we'll see you back on Thursday on the competency calendar, which is generally 11 o'clock.
Thank you, Your Honor.
Okay.
Position.
That's it.
Mr. Johnson,
Is this Kevin Johnson?
I'm gonna need to speak with them.
Is it Kevin Johnson? Is that right? Yes.
yes, sir.
All right. Good morning, Mr. Johnson. He's position number 17.
And Judge, I'm gonna need to speak with Mr. Johnson before we accept the position.
Okay. So are you able to call, or how can we accomplish that?
Yes, I will call courtroom 2.
Okay. Thank you. Who do we have? Thank you. Who do we have at 4 North?
Position number 42 through 45, Mr. Yarbers.
Mr. Yarber should be in arraignment today. It's not guilty, Your Honor.
Okay.
We have copies of the accusations, and we'll waive formal reading of that.
Good morning, Mr. Yarber. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Yarber. You've been charged in case 23 CR 001135F with battery, family violence, and criminal trespass and damage to property. In case 23 CR 00114005 with battery, family violence. In case 23 CR 001141F with battery, family violence, and in case 23 CR 001142F with battery, family violence. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. It's my understanding, Mr. McClain, that you're waiving formal reading of the accusations. Is that correct?
That is correct, Your Honor.
How do you plead to these charges, Mr. Yarber? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned, your cases will be returned to the division judge, and you'll get notification of your next hearing date. Good luck to you, sir.
Thank you.
Okay.
So obviously, you gave them $500. You had your family be able to help you buy it. You didn't have that lower. Okay. So would it help if I got lower? Okay, all right, so right now it's 5,000 shares. I'm gonna ask that you lower to $3,000. For sure, and that way maybe. Okay. Obviously, I know you're coming on work here and then still.
Okay, we will be in recess until someone returns.
Lisa, Roku, Rug.
This, position 17.
Okay, and what are we doing with Mr. Johnson? You're on mute, Mr. Finland, if you're speaking.
Yes, sir.
Mr.
Not talking.
Johnson, yes, Judge, Mr. Johnson is gonna plead not guilty. I just want to briefly address bond for him if I can.
Okay, do we have his bond? Let's see, Mr. Johnson, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Mr. Johnson, you've been charged in case 23 CR 001093B with loitering and prowling, willful obstruction of a law enforcement officer, and possession of a pistol or revolver by a person under 18 years of age. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Finley?
I do, Judge.
How do you plead to these charges, Mr. Johnson, guilty or not guilty?
Not guilty.
We will record your not guilty plea. The case will be returned to the division judge and you will get notification of your next hearing date. Let's see, on February 27th, I set the bonds in this case for the loitering and prowling, $1,000 good bond, for the obstruction, $1,000 good bond, and for the possession, a $3,000 good bond, making for a total of a $5,000 good bond with a curfew from 9 p.m. to 6 a.m. How have the circumstances changed since this bond was entered? Mr. Finley?
Judge, I was just gonna ask for it to be slightly changed just to help his family afford the bond. I know they're trying to get money together right now to afford the bond. They're not there yet. So that was really kind of like the main goal of this, Judge. But I do know that he lives with his mom. He is 17 years old, Judge. He's November 2005, so 3.5 months ago, he was 16 years old. But I know he lives with his mom. I was unable to reach his mom just now, but just wanted to slightly lower it, Judge, so his family can have a better opportunity to afford to get him out.
What, I think I was concerned when I set this bond that he had a place to go. And that his mother, and I was concerned that his mother wasn't present. I'm also concerned that she's not present this morning, especially given his age, and if they are seeking to come up with the money for the bond. If you want, I would be more inclined to help you out, Mr. Finley, if I could speak with her, especially since he's going to be going, if he gets released, I anticipate to live with her. So if she could be on the call, that would be helpful for me to address her directly.
Judge, could I try to call her one more time really quick? Is that okay?
I'm happy to give you the opportunity to give her a call, and also would be happy to put it on the calendar for next Tuesday if you want, if he doesn't make bond by that time, and if she wants to come in and speak to the court. My biggest concern is that he has a place to stay and that she's going to somehow monitor him, and that I'm not sure if he's in school or anything of that nature. But if you want to present to me those kind of things, and I would be certainly willing to listen to a modification.
Okay.
So, request.
I guess I can try to reach her right now. I know it'd probably be more effective if we could get her on the Zoom, and hopefully she could probably make that happen.
So if you want to try to see if she can get on before the end of court today, I'm happy to address her. If you can't, and you want me to reset it again for next week, I'm happy to do that also.
Understood, Judge. I'm gonna give it a quick, I'm just gonna.
Okay, that's fine.
Really quick, try it.
And Ms. Campbell, I know, I'm sure that you're gonna have something to say about this also. So if we do get her on, I'll let you question her and you can make your presentation to the court. If not, then we'll just do it all next week, if that's okay with you.
Okay, thank you, Your Honor.
Okay, because if you tell me now, Ms. Campbell, by next week, I'm not gonna remember.
Okay, thank you.
Okay, who do we have next? And I see two gentlemen that are under Mark Woodhouse. Are you all here for someone in court today? Are you here?
You have to mute it.
He's the victim on our DV calendar, Your Honor.
Okay, is this, because
we're actually in the meeting as well, just having some technical difficulties. But we are actually in the meeting. The
okay,
attorney as well as everybody's in the meeting.
okay, so let's see, I only have one. Do we have more than one DV? The only person I have this morning for my DV bench warrant calendar is a Jaffa Fielder.
Jaffa Fielder,
Jaffa Fielder, and represented by Cheryl Freeman.
Yes.
Okay, and so who do we, hi, good morning, Ms. Freeman.
Good morning,
Let's
how are
see.
you, Your Honor?
I'm doing well. And so who is it Mr. Fielder?
Yeah, it's Jaffa Fielder, and I believe, and this may have been the issue last time he didn't appear, is they're having problems getting into the Zoom, Your Honor. If the court will allow, if I can reach out to them to check on their technical difficulties.
Yeah, because
Okay.
I'm actually in, but I don't know if you guys can see us.
No, is this Lauren Green?
Actually, it's Dr. Paula Green Fielder. I believe it's under Lauren.
Okay, and are you able to activate your camera?
That's what I'm trying to do now.
No, she's not logged on to the camera. She may have to log out the Zoom and accept it and make sure that your allowance on your phone allow you to get into you have to allow it to accept your camera.
Okay, and that's what I am absolutely trying to do. It looks
May
like
have to
they're
log, you're gonna have to log all the way off and then log back on and then select allow. It will prompt you.
not a problem. I'm going to we're gonna log out because he's on as well, and so I'm gonna log out and I'll log back in.
Okay.
Okay.
See you tomorrow. Ms. Redden.
And Judge, for position,
Yes.
yes, sir, for position 17, Johnson, I was unable to get a hold of his mom, so if we could reset that one, and I'm gonna make a note for them to try to get her on that Zoom for that day.
Okay, so we're gonna reset that for the 21st. Okay,
All right, perfect, thank you.
Your Honor, is it possible I can request a breakout room with me, ASG Dillingham, and Mr. Woodhouse, please?
you, Ms. Dillingham, and Mr. Woodhouse,
Yes,
okay?
sir.
Yes. So if we can put Ms. Dillingham, Mr. Walker, and Mr. Woodhouse into a breakout room. Okay, who do we have at 3 South?
This is Bryant, position number 5 and 6.
What's the announcement on Mr. Bryant?
Sorry, I was on mute. This is gonna be a plea, and Mr. Bryant still wanted to move forward with the plea like we talked about yesterday.
Can you hear us, Mr. Bryant?
Yes, sir.
Okay, did you hear what your counsel asked you?
Yes, sir.
And,
Yes, I would.
Okay, all right, so yes, we're gonna move forward, Judge.
Okay. Good morning, Mr. Bryant. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Good morning.
Good morning, sir. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down, Mr. Bryant. Ms. Campbell? You're on mute.
Can you hear me now?
Yes, thank you.
Okay, the offer for Mr. Bryant is 12 months to serve, 30 days credit for the time he's already served, 15 days. The balance is probated. He's to complete a family violence intervention program, have no further contact with the victim, and stay away from the incident location. That's as to position 5. As to position 6, the recommendation is 12 months to serve, 30 days. Credit for the time he's already served, 15 days. Balance is to be suspended. And he's to stay away from 251 Howell Drive Southwest. The address, the stay away address for position 5 is 5510 Sturbridge Way in Atlanta. And the victim's name is Marcus McClare, who is the defendant's ex-boyfriend. Nothing further.
And, okay. Let's see. Mr. Finley?
Yes, Judge. That was our understanding of the offer for both positions. For position number 5, I would just ask that once he does complete the family violence class, his probation could be non-reporting. And also if the fees could be waived for a period of time. And then on position 6, obviously agree to the time served and balances.
Okay. Mr. Bryan, it's my understanding that in case 23 CR 001173A, you wish to plead guilty to willful obstruction of a law enforcement officer, simple assault, simple battery, and criminal trespass and damage to property. And in case 23 CR 001174A, you wish to plead guilty to willful obstruction of a law enforcement officer. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the pleas as negotiated. Mr. Bryant, on position number 5, I'm going to waive 3 months of fees to give you the opportunity to get a job. And when you complete the terms of the probation, it'll go to a non-reporting status. Good luck to you, sir.
Position number 27, Parker.
And this is going to be an arraignment, Mr. McLean?
That is correct, Your Honor.
I believe this is Ms. Dillingham's case, and I think she might be in the breakout.
Okay. Can you sit in for her for the arraignment? I'm not going to need any of the facts. Is that fine with you, Ms. Campbell?
Yes, Your Honor.
Okay,
Right.
thank you.
Mr. Parker is here to simply plead not guilty.
Okay. Mr. Parker, good morning. I'm Judge Young. Good morning, sir. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes.
Can you
Yes, sir.
Can you raise
Yes,
your
sir.
hand? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Parker. You've been charged in case 23 CR 000893A with reckless conduct, disorderly conduct, and willful obstruction of a law enforcement officer. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We do, Your Honor. We have copies and we have read them.
How do you plead, Mr. Parker? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, sir.
Thank you.
Thank you, Your Honor.
Okay. Is there anyone else who can take it 3 South? Okay. Can we mute 3 South, please? Thank you. Let's see, while we're waiting for someone else for the state all-purpose calendar, are we able to move forward with the DV bench warrant calendar?
Yes, Your Honor, I believe my client, Mr. Jafa Fielder, is on, as well as his mother, Mrs. Dr. Fielder.
Okay. And Ms. Dillingham, it's my understanding that Mr. Fielder is charged with simple battery, family violence, and that he missed a court date at some point.
Yes, Your Honor, he did recently miss the most previous court date where the victim did show up, and he was not there. Are they on right now? I don't see them on the Zoom.
I see him in the participants, but I don't see, they'll both need to activate their camera.
Okay, just before I read the facts of the case. Okay. So yes, Your Honor, this incident occurred August 21st, 2020, where officers responded to 1256 Ralph David Abernathy, the resident of the victim in this case, Mark Woodhouse, who was a roommate with the defendant at the time. Upon arrival, the officers learned that there was an argument that escalated to the defendant busting into Mr. Woodhouse's door of his bedroom, to which he began attacking him and hit him in the face. Your Honor, since this incident, the defendant has been contacting Mr. Woodhouse, and the defendant's mother has also been contacting Mr. Woodhouse multiple times, sending numerous text messages and phone calls harassing him regarding this incident. So we do have concerns regarding that. The state's recommendation in this case is 12 months to serve, 4 days credit for time served, 2 days with the Family Violence Intervention Program, and then a stay away order from the address 1256 Ralph David Abernathy, and no further contact with Mr. Woodhouse.
It was a bind over case.
Okay, and what court date was missed?
It was a plea and arraignment on February the 2nd. I mean, February the 6th.
I believe it was. Give me one
I'm
moment.
told it was a plea and arraignment on February 6th
2020.
of this year. Okay. Anything further, Ms. Dillingham?
Nothing further from the state, Your Honor, unless Mr. Woodhouse would like to make a statement. He is on the Zoom, so we would call for him.
Okay, I'm gonna hear from Ms. Freeman first, and then if you I would like to say something or address the court, I'll allow it. Yes, Ms. Freeman.
Yes, Your Honor, thank you. So as of today, we're just prepared to move forward on a motion to set aside the bench warrant. It's my understanding that February 6th was an arraignment calendar. At the time of the arraignment, it's my understanding, I wasn't counsel at the time, but it's my understanding that a Zoom link was sent to Mr. Fielder, and they were waiting to get in on the Zoom link. And then afterwards, when they were not allowed on the Zoom link, they called the court immediately, and they were advised that they were supposed to appear in person. Now, I have been in communication with Mr. Evan Dudley prior to my filing my entry. We have not been able to discuss the actual facts of the case. I did file a discovery motion. So at this time, Your Honor, we would just ask that the court set aside the warrant so that I can get the discovery and speak to my client regarding the facts of the case. He is present today. And again, like I said, Your Honor, he was present on the Zoom call, but was not let in with difficulties. And immediately after that Zoom hearing, they have been in communication with Mr. Dudley as well as staff with the court.
Okay, thank you, Ms. Freeman. Anyone else like to address the court on this issue before I make my ruling? Okay. It is this court's practice to set aside a bench warrant on one occasion. Given the circumstances of this case, I am going to have it set aside. That only happened, and I understand that you did the right thing, Mr. Fielder, by immediately calling the court. But make sure that you, in the future, get to those hearings. So we'll set it aside this time, but it won't be set aside again in the future, okay?
Yes, sir.
All right. And Ms. Freeman, can you prepare that for the court?
I do, and I will get it right over to, I believe, Ms. Katrina, is that correct? Yes, yes, Your Honor, I'll get that over right now.
Okay, that's very good. Thank you very much. All right, nothing further. Y'all have a good day.
Thank you. You too. Thank you, Your Honor.
You're welcome.
Position number 1 and 2, Mr. Allen on 3 South.
Okay. And this is a negotiated plea, is that right?
That's correct.
Oh, he talking about me?
Good morning, Mr. Allen. I'm Judge Eric Morrow. This is the State on Purpose calendar. Good morning, sir.
All right.
Good, good. We're conducting this by video. Do you agree to have your case heard by video?
Okay, yes, sir. Whatever you say, Your Honor.
Okay.
Yeah.
Can you raise your right hand for me, Mr.
David
Allen?
Allen.
All right. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand in. Thank you, Mr. Allen.
Okay.
Ms.
Okay.
Kemp?
All right.
You're on mute.
Okay, thank you, Your Honor. The recommendation for Mr. Allen is 12 months to serve 12 days. Credit for the time he's already served 12 days. and the balance is to be suspended. The state's also requesting a stay away from the West End MARTA station, which is located at 680 Lee Street in Atlanta. And the state pursuant to Mr. Allen entering a guilty plea on position 1 is going to no pros his FTA case, which is position 2. Nothing further.
Okay, Mr. Finley?
Yes, Judge, that was our understanding of the plea of the time served and no probation, of which we do agree.
Okay. Mr. Allen, it's my understanding that in case 22 CR 004451J, you wish to plead guilty to fare evasion, is that right?
Okay, I guess I do that. You say your time served on that? Yes, sir.
Okay,
I hope I said that right now. Did I say it right?
yes, you did. You said yes, didn't you?
Okay, all right.
Oh, okay. Are you under the influence of any drugs or alcohol this morning?
No, sir.
Okay.
I'm in this game.
Okay. You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury. You don't want a jury trial, do you?
Oh, no, sir. No, sir.
Okay. You've been represented by Mr. Finley. Are you happy with what he's done for you?
Yes, yes, just whatever y'all, I'm a yes man. That's all I can say is yes.
You don't have to say yes.
I'm ready to go home.
Has anybody forced you or coerced you to plead guilty?
No, sir.
No. All right. Now, I'm going to accept your plea, Mr. Allen. You know you can't go back to that West End MARTA station, okay?
Okay, all right. Hey, that's it. Hey.
All right. Good luck. Good luck to you, Mr. Allen.
Oh, well, can I ask you a question? Can I ask you a question?
Mr. Allen, it's not about the facts of your case, right?
Oh, no, I just want to know, how long will I be in here before I get out?
Well, if you don't have anything holding you, as soon as the jail can process you out, we're going to have to get them the paperwork. And as soon as they get the paperwork, and they'll start to process you out. So as soon as they can get that done.
All right. Okay. Just thank you. That's all I need.
All right. You have a good day, Mr. Allen.
All right. You too. Good to see you, man.
Position 39, Mr. Williams.
Okay. What are we going to do with Mr. Williams today?
I need to speak to Mr. If that's Mr. Anthony Edward Williams, I need to speak to him.
Yes, sir.
Okay. I guess we're going to have to put you into a breakout room.
Yes. Correct.
Okay, so if we could put the jail court's iPhone 2 and courtroom 2 into a breakout room, please.
That's not enough.
We'll be in recess until they return.
Are we ready, Your Honor?
Yes, is Mr. McLean back?
He should be.
Mr. McLean, are we ready to move forward?
Oh, we're unmuted now. Thank you. Anthony Williams will be a not guilty. Let's arraign that, Your Honor.
Okay, Mr. Williams, can you raise your right hand for me?
Yes, sir.
Do you swear to affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Mr. Williams, you've been charged in case 23 CR 001074 F for simple battery. This charge carries a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We do, Your Honor.
How do you plead, Mr. Williams? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date, sir. Good luck to you.
Yes, sir. Thank you, sir.
Thank you.
Yeah.
All right, sir. Okay, so we still have about four more positions, I believe, so.
Your Honor, do you have handy which position numbers those are?
I did. We have positions 3 and 4. Bailey Brown. We have positions 12 and 13. Keandra Ford. We have positions 35 and 36. Joseph Robinson. We have position 41, Donkez Wright.
Donkez Wright, according to our paperwork, was released from jail. Is that correct?
Okay, that's what we have down also, Mr. McLean. So.
And Robinson, Your Honor, 35-6 is going to be an arraignment, not guilty.
Okay, so we'll get him. 12 and 13, I have negotiated plea, and 3 and 4, I have an arraignment and bond hearing.
That's correct. And in number 3 and 4, that's a female as well.
Okay. So I don't know why she wasn't brought over from ACDC if that's where the females were today. Is there anyone in the courtroom with you all that can call over to ACDC to see if they're gonna have Ms. Bailey Brown present?
Officer Norris is gonna call.
Okay, thank you.
I should memorize the number. You guys are here for appearance, aren't you? You're here to be interviewed on film. Mr. Mean. Mr. Mean. You finished? Yes. I'm gonna hang up the phone. Let them just.
While we're waiting, it's okay with everyone else, I'm going to let Ms. Lewis go over the calendar so we can, have that done. So,
Good morning. Can everybody hear me?
Yes.
The add-on, number one, it was a plea. We're going to the regular calendar. Position number one was a plea. Position number two was non-pros. Position number 3 and 4 were still pending. Position number 5 was a plea. Position number 6 was a plea. Position number 7 was a plea. 8 and 9 was a plea. Position 10 was non-pros. Position number 11, defendant was arraigned, not guilty. Cases reset for the SAP for next Tuesday, March the 21st. Position 12 is pending a plea. Position 13 is pending a plea. Position number 14, defendant was arraigned along with his companion case on Thursday calendar, not guilty. Cases reset for trial further notice. Position number 15, defendant was arraigned, not guilty. Cases reset for trial further notice. Position 16 was a plea. Position number 17, defendant was arraigned, not guilty. Cases reset for the SAP for possible plea for March the 21st. Position 18, defendant was arraigned, case not guilty. Cases set for trial further notice, amended bond order of a SOB through the jail of $2,000. Position 19 and 20 is going to be set to the competency counter for Thursday, which is March the 16th. That's going to be an add-on. Position 21 was a non-pros. Position number 22 was a plea. Position 23 was a plea. Position 24 was a non-pros. Position number 25 was a plea. Position number 26, defendant was arraigned. Cases reset for trial further notice. Position 27, the same announcer, the defendant was arraigned. Cases reset for trial further notice. Position 28 is reset for the SAP Tuesday, March the 21st, along with position 29. Position 30, 31, 32, 33 is all reset for the SAP for March 21st. Position 34 was a plea. Position 35 and 36 are pending arraignment right now. Position number 37 was a plea. Position number 38 is reset for the SAP 2 weeks out, which is going to be March the 28th. Position 39, defendant was arraigned, not guilty. Cases reset for trial for the notice. Position 40 was a plea. Position 41, you're still holding. Then, I'm sorry, 41 was released. Case is going to be reset for the notice. Position 42, 43, 44, 45, and 45. All those were arraigned. Case is reset for trial for the notice, and 46 was a plea. Any questions, commissioners? Please make sure I got all the null process. I did see them. However, I wasn't able to open them up at the time to make sure they were correct. And all plea paperwork, please make sure you send it all to me in a timely manner. I appreciate it. Thank you.
okay, I guess we'll be in recess until we get someone else, one of these last 3 positions.
Hey, Judge.
Yes.
Hey, Judge, Mr. Robinson, is gonna be a reset. They had, a big miss going on up there in 3 South 400, the inmates, so he's gonna be a reset. I
Okay,
wasn't able to pull him out because of the altercation going on.
okay, so is that gonna, we have 3 positions that we need to address. Are all those gonna be reset?
So I know one, officer's talking about, and then mine is the female position 3 and 4. And
Yes.
Judge, I'll go ahead and ask for a reset on that one as well. That was gonna be addressing bond, asking for a signature bond. That being said, Judge, full disclosure, I think she gave me not a real address. So I'm gonna need to have a social worker meet with her. So she wasn't, gonna be able to get out anyways without an address. So,
Okay, 2 or 3 weeks, Mr. Finley?
yeah, if we can, have that out to, we'll say 2 weeks, and I'm just gonna have a social worker meet with her to try to get her address.
Okay, so position 3 and 4 reset 2 weeks,
328.
328. And was it Mr. Ford that we were talking about that needed to be reset?
Joe Robinson.
So,
The guy,
okay, so his was,
35-6.
okay, so
Oh, Mr. Robinson, Mr. 35 and 36.
that one, and then Ford is my client. I'm not sure where he is.
Okay. So 35 and 36,
Is the
Mr.
one,
Robinson is just, it looks like it's just gonna be an arraignment, so we can reset Mr. Robinson for next Tuesday. Is that
And then-
all right?
yes, sir. And then I would like to get, I'm not sure where Mr. Ford is. I met with him yesterday, and that one is time served.
Right, and is he not gonna be able to be brought either? Is he part of that alter?
I don't have where he, let me see.
What is the person's name?
Oh, you know what? Actually, I do. He was on 2 South when I met with him yesterday. Oh, yeah. Keandre. You don't use, no.
Nor should have that.
Yeah, I don't know where he was.
So is she trying to find him?
Yeah, so I think, it's the last one.
Okay, so we'll be in recess until she returns.
Okay, I'll keep you updated.
Which position?
So. the
12 and
last
13.
12 and 13. Judge, they're on the way to get Mr. Ford.
Okay, thank you.
On the medical records section, in the bathroom, there's a CRCP. That's what I seen. And then I go in the parking lot and on my phone and then I log in. Right. How you doing? No, that's coming. Hey, so. Hello?
Here.
Oh. Yeah, you got to get something going to the ground. She doesn't want to report, I told her to bring our cell phone to her, and then you can do it that way. She still wants to wake up. Hold on, but I have. I think, is that the only one that you have? Okay, these two are very, okay. I'll put you, give me about 10 to 15 minutes, okay? Okay.
Judge Morrow?
Yes.
Today's my last day in state court. I just want to say it's been a pleasure working with you and just want to say
Oh,
that.
thank you, Ms. Campbell. It's been a pleasure working with you. Thank you for letting me know. Where are you headed?
I'm going to be a senior judicial staff attorney in magistrate court. So I'll still be in Fulton, but I just won't be in state court anymore.
Oh, okay. Well, fantastic. I hope you enjoy that position.
Thank you.
You've been a pleasure to work with, so I appreciate it.
Same, very much so.
Thank
All
you.
right, thank you.
Okay.
Hold on a second, Ms. Campbell. This is Ms. Lewis. I know I'm not on the line, but any way you can get the other non-cross to me or love?
Oh, the one you just emailed me about?
Yes.
Okay, yes, I can do that now.
Okay, and can you mark which they're supposed to be, Mr. Walker on the line to let me know?
Yeah, I was saying Mr. Walker can make that call since he's the supervisor. Did you want their records to be restricted or not, Ian? No, if he's
I'm
there.
sorry, what was that?
Ms. Lewis is asking if, when we're doing the no process, are we agreeing to restrict the
Yes,
record or not?
that's we typically do.
Okay, thank you.
Uh-huh.
I'll be waiting for that. That's the only one I'm waiting for.
Okay.
Thanks for letting me know.
Is this Mr. Ford we have?
Yes, sir.
Yes, thank you. Good afternoon, Mr. Ford. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Who's presenting for Mr. Ford?
I am, Your Honor. And Ms. Dillingham, that was her case for Trayon Love. So she's gonna be sitting over the no pros, Ms. Lewis.
Thank you.
You're welcome. So the state's recommendation is going to be 12 months. Is this Mr. Ford?
That's right, 12, position 12.
12 months to serve 18 days, credit for the time he's already served 9 days. The balance is to be suspended. And pursuant to him entering a guilty plea on position 12, the state is going to be no processing position 13, the FTA case. And I did already send that form over, nothing further.
Okay. Anything, Mr. Finley?
That is our understanding of the plea. We do agree, Judge.
Okay, Mr. Ford, it's my understanding that in case 21 CR 006347J, you wish to plead guilty to criminal trespass and obstruction of a law enforcement officer. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this afternoon?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Ford. Good luck to you, sir.
Okay, what will I be released time served?
It's a time served plea, Mr. Ford. As long as you don't have anything holding you in, you'll be released as soon as the jail can process you out, okay?
Okay.
All right, good luck to you.
Thanks.
All right, thank you all. Appreciate your patience today. Good luck to you, Ms. Campbell. I hope to see you in the near future. And
Thank you all.
nothing further. Thank you all.
Have a good one.
I'll see you all next
Thank
week.
you, Your Honor. And Ms. Lewis, I'm sending that over right now.
Thank you.
Okay.